Welcome to the Neighborhood Law Center. I'm your host, Melvin Burris, and our guest is Attorney Lewis Martin III. Welcome, Counselor. Our topic today is how to protect your family and your assets. And we're going to begin first by asking Counselor to just give us a little background about yourself.
Well, I was born in the University Hospital 65 years ago, this past May 8th. I've been in Charlottesville all my life with the exception of 2 years in the United States Army on active duty over 40 years ago when, as they say, I was a soldier once and young. But I've practiced law here in Charlottesville going on 38 years and think that Charlottesville is a great place to live.
Okay, thanks. Let's get started now. We're going to talk about wills in Virginia. As you know, many people have questions that they often occur on the subject of wills. So we're going to break that myth there and talk about wills. Let's talk about first, can I write my own will without an attorney?
Yes, you can. In Virginia, you can write what is called a holographic will, and a holographic will is a will that is entirely in the handwriting of the person who is making the will. The legal term for the person who makes a will is a testator. And that will does not have to be witnessed, but when the person passes on, it will require two disinterested witnesses to the testator's handwriting to appear in the clerk's office and or by affidavit if they can't make it to the clerk's office because they live a distance away and swear that that is the handwriting and they're familiar with the handwriting of the person who wrote the will. I don't recommend writing a holographic will. One of my legal assistants many years ago gave me a sign which is prominently posted in my office and it says, "The man who dies without a will, or woman who dies without a will, has lawyers for his heirs." And the problem with writing a holographic will is that the person who writes it unquestionably knows exactly what they mean but when they write it, but because of the nuances of the English language, not everybody else will be able to figure that out. And I've often told people that people who wrote holographic wills or people who died without wills enabled me to pay for a large part of my son's college tuition.
Okay, let's back up a little. What is the purpose of a will?
Well, the purpose of a will is to ensure that your assets, that is the assets that are titled in your name, pass to the beneficiaries that you want them to pass to. And if you don't have a will, then your property is going to pass in accordance with the Virginia statute for intestate distribution. And that is a statute that was created many, many, many years ago. For instance, if you are married and you've only been married to one person and that person is the mother of your children, then your spouse, in that case, would take everything that you have. If you die without a spouse but you have children, then your children would take. But let's say that the person to whom you're married is not the mother or the father of your children, and then you pass on, well, 1/3 of what you have is going to go to your spouse, and 2/3 will go to your children. And that's not necessarily the way that people want their property to pass. You can have even more unusual situations. I had a situation about 10 years ago where a man had been married to a woman who was not, and he was not the mother of her child, but she was like his only child because he had married her when this young lady was a girl, and they had done wills, and he had left everything to first his spouse, who died before he did, and then his beneficiary was his stepchild, but he never adopted the stepchild. About 2 weeks before he died, he remarried someone who was in her 60s, and unfortunately had a heart attack when he came back from his honeymoon and died. And the way that the Virginia statute works is that under that situation, his remarriage, revoked his previous will, and so his stepdaughter was left out, and everything went to his, if you will, trophy bride.
Okay, well then another good question would be, who should have a will?
Well, everyone should have a will for the reason that I just said. Even if you have the Leave It to Beaver family, where mother and father have only been married to each other, and all of the children are the children of both of them, it's still important to, because you never can tell what's going to happen, particularly if you live a long time and you become incapacitated, and then something happens to the people who would otherwise be your beneficiaries if you didn't have a will. In some cases, particularly also for people who don't have lineal descendants, that is children or grandchildren, they may want to, would prefer to leave their property to an institution or charitable organization, a church for instance, and if you don't have a will, your property is going to pass, depending on who your closest relatives are, to first and second cousins, and I've seen that happen as well.
Okay, one thing as you were speaking, I was concerning, well, what provision should be in a will?
Well, you want to deal with the distribution of your property that doesn't pass by other means. There are other ways to ensure that your property passes when you die. For instance, if you own property with your spouse, for most married couples own their personal residences, their real estate, as husband and wife as tenants by the entirety. That's in the deed when the property is conveyed to the husband and wife. That's the way it's titled. And so the will is not effective with regard to that property. That property automatically passes to the surviving spouse by operation of law. With a bank account, for instance, you can have the property titled as joint tenants with right of survivorship with someone other than a spouse, a child, for instance, or a sibling, or even a parent, perhaps. And you also can have accounts in your own name, bank accounts, which you make pay on death, POD accounts. If you have a brokerage account, an investment account, or stock certificates, you make them TOD, or transfer on death. And so those act as essentially will substitutes. There can be problems with that, though, because you can't, for instance, with a pay on death bank account, ensure that, let's say you have 3 children and then one of your children passes away, and you forget to go and change the pay on death beneficiary. Most people would like for that property to pass to any children of that child. So the grandchildren would take the child's share. If you had 3 children, there would be a 1/3 share, and let's say that child had 2 children, then they would each get half of the parent's 1/3 share. And so, but the pay on death way of holding things would dictate that the property pass to the 2 surviving children, and the grandchildren, the children of the child who predeceased you, wouldn't take it. In recent times, too, our legislature, the Virginia legislature, has been very proactive and very good about trying to ensure that property passes the way that people want it to, and to enable people to avoid the probate process if at all possible. And we can also do what's called a transfer on death deed, just like a pay on death bank account or transfer on death brokerage or investment account. You can actually do a deed, and husbands and wives can do this, or individuals can do this, and you can designate the people who will take title to the property when you die. And then if you do that, if you do a transfer on death deed, it doesn't take effect until you die. You can still sell your property. Then those people's transfer on death benefit would, of course, be eliminated if you sold it to somebody else. Or you can change your transfer on death deed at any time before you die. And that's another way of getting property to pass. There are also beneficiary designations that you make on your retirement plans, 401ks, IRAs, and on insurance policies, and on annuities, and other types of contracts with assets, and they ensure that the property passes other than under your will. So that what the will transfers is property that is titled in your name and not titled some other way.
Okay, it's a good scenario. The question I would have is, husband and wife, both of them have kids, separate kids. This is their second marriage. They have the kids. They have a home, tenants by entirety. Is one of them's desire is to pass their share down to their children. So you're saying that, for instance, if it was my children, they would not get a share if I had a tenants by entirety?
Well, they wouldn't get a share until the surviving, let's say you pass on first and then your wife continues to live, then if you held title as tenants by the entirety, she would get the whole thing. And so here's where that's called a blended family, where you have children by a prior marriage or other relationship, and your spouse has children by a prior marriage or other relationship. And that's where a marital agreement would come in handy, or an agreement in connection with your estate planning would come in handy. And you don't simply have to have a marital, you can have all kinds of marital agreements, not just separation agreements when you're getting ready to divorce, but you can also have agreements with regard to your estate planning. And so that you could still hold title as husband and wife as tenants by the entirety, but then you might have a separate contract or marital agreement with your spouse, such that each of you sets up your wills or trust, for instance, to attain the result that you want when the last of you passes on.
Okay, all right. It's good to know. Sometimes, as you know, Virginia is a transit state. And a lot of people, they reside here, they go to school here, but then they leave after 4 or 5 years working here to move on to Washington, D.C. or other areas. So will a will be, if I made a will in Virginia, will it be valid in another state or district?
Absolutely, and this is where that concept that you may recall from your 12th grade government class or your high school civics class, full faith and credit under the United States Constitution, and each state is required to give full faith and credit to the legal acts of citizens of other states. And so if you have a will in Virginia that is legal in Virginia and has 2 witnesses, that is going to be valid in every other state. I have a question about whether a holographic will done in Virginia would necessarily be valid in another state, because there are some states that do not recognize holographic wills. But if you have a will that is witnessed by 2 witnesses and otherwise in good legal order, and you signed it at the bottom of the page, then that will should work in just about any other jurisdiction. Now, having said that, probate and real estate laws are very state specific, and there are some states that have very modern state codes. There are other states that have codes that state codes that are not as user friendly as Virginia's are. And if I'm doing a will for someone who owns real estate in another state, then I will always have the will or the trust that I'm working on reviewed by an attorney in another state. For instance, my mother-in-law, who's 91 years old and was born on the same day as Queen Elizabeth, owns real estate in Texas. And she also owns real estate in Nevada. And so in the process of updating her estate documents recently, I had her estate documents reviewed by an attorney in Texas and also by an attorney in Nevada to ensure that the will had all of the bells and whistles that each of those states wants to see with regard to the transfer at death of someone who owns real estate in that particular jurisdiction. And also, having said that, one of the devices that the viewers have probably heard about is called a revocable living trust.
Okay,
and
let's break there, and we'll get back to that and probate, okay?
Sure.
All right, this is the Neighborhood Law Center. I'm Melvin Burris. Our guest is Attorney Lewis Martin III. Our topic is protect your family and your assets. We're talking about wills, probate, and other items that pertains to transferring your assets to your family. Okay, so now we're going to get back to
the revocable living trust.
Okay.
Back in 1980, we had a significant change made in our federal estate tax laws. And at that time, many estates were subject to the federal estate tax. It worked its way up. The exemption amount at that time, I think, was about $275,000. By 1987, the exemption amount had worked its way up to $600,000. But as most of your viewers know, you can develop a $600,000 estate with a moderate house and life insurance policy. And so many people were otherwise subjected to the federal estate tax. Now, there was also an unlimited marital deduction. And so that would enable people to pass property to a surviving spouse without the federal estate tax being involved. But then at the death of the surviving spouse, the children would incur an estate tax. And so the revocable trust came into being as a way to ensure that each spouse was able to take full advantage of whatever the federal estate tax exemption was at the point of death of the last spouse. And so in this, the amount gradually worked its way up to $1 million in 2001. And then we had a period where it was in a state of flux. By 2009, it had worked up to $3.5 million. In 2010, when John Kluge died, you had a choice. You could either have an exemption amount of $5 million, or you could have an unlimited exemption. And there were reasons that you would not want to have an unlimited exemption, because you would not get what's called a stepped up in income tax basis for assets that pass at your death. That's probably a little beyond the scope of our conversation here.
So.
But in any event, many people used revocable living trust for purposes of avoiding federal estate tax and ensuring that both spouses were able to take advantage of whatever the maximum estate tax exemption was at the time the last spouse died. But it's also a device that you can use to avoid probate. And some states have much more onerous probate processes than Virginia does. In Virginia, the cost of probating your will is like the cost of probating a deed.
Okay, tell our audience what probate is.
Probate is when you take the will down to the clerk's office and you show it to the deputy clerk. Usually there's a deputy clerk for probate, or sometimes the circuit court clerk, his or herself, will do this, him or herself, excuse me, and then they look at it and they say, okay, I can see that this will was executed in accordance with Virginia procedures, and I'm going to say that this will has been proven to be the last will and testament of the person who wrote it, and I am therefore going to admit it to probate, which means that it effectively transfers the property that is subject to the will. That is, property that's not otherwise transferred by some of these other methods that we talked about a few moments ago. And then it also permits, if necessary, the person who's named as executor in the will to qualify to administer the estate. And we can get in a few minutes as to why you might not want that person to have to qualify. But in any event, that's what probate is. And in some cases, in Virginia, the cost is like 1/1000th of a dollar. So, for instance, if you had $1 million estate, the cost of probating the will would be approximately $1,333.33 plus some additional fees. In other states, it would be much more than that. And so if you have transferred title to the property that you would otherwise pass by your will to a revocable living trust, then that property isn't governed by your will anymore. It's governed by the terms of the trust that you created, which essentially becomes a will substitute.
Okay. So now you just mentioned something very important: an administrator or an executor that's named in the will. Tell our audience how important that is.
Well, it's extremely important, because you want someone who will get in there and quickly and efficiently administer the estate, who will know how to deal with assets. For instance, if you have a lot of assets and the stock market appears that it's on the verge of crashing, you want someone who is going to know how to dispose of those assets before the stock market crashes. If there are complications with regard to other assets, you want somebody who knows either personally how to deal with those assets or who to hire, attorney, accountant, financial advisor, to help them through the probate process until the property can be dispersed and distributed. And sometimes estates can go on for a number of years, particularly if there are minor children involved. These estates will typically have testamentary trusts that won't disperse until the children attain a certain age. And in this day and age, it's typically 21, 23, 25, or depending on the size of the estate, maybe even older, because as most of our viewers who have children at that age, and all of our viewers who have at one point in their lives been at that age, you know that sometimes it's not a really good idea for a 21-year-old or a 20-year-old or a 19-year-old or a 17-year-old to come into a six-figure inheritance.
Okay. Look like we're running out of time, but we want to talk about the Virginia Small Estates Act.
Yes, the Virginia Small Estate Act enables you to dispose of assets. Let's say, for instance, that you have a $600,000 estate, but you have disposed of $550,000 worth of property by these other means: pay on death, joint with survivorship, transfer on death, beneficiary designation, whatever. And so you've got $50,000 or less in personal property. You could have $10 million in real estate, but if you have less than $50,000 or less in personal property, if there is a will, you probate the will, but the executor doesn't have to qualify, which involves additional expense and court filings and court supervision. But 60 days after the person who wrote the will dies, or even if there is no will, 60 days after death, if there is a will, you have to probate the will, and then there's an affidavit that has about 8 sections to it. And when I say 8 sections, it's not very elaborate. It's just the person's dead. They either had or they didn't have a will. If they had a will, I probated it. These are the people who are entitled to the property. They've designated me as the person to get the property. And then you go to the bank and you get the $25,000 bank account, or you go to the brokerage firm and get the $10,000 investment account, or you go to the state and get the $2,000 state income tax refund. And as long as all that together is under $50,000, then you don't have to get involved with accounting to the Commissioner of Accounts, who's a lawyer appointed by the court to review executors and administrators and testamentary trustees and conservators' work and what they've done with the money, and then you just get it and distribute it out as it's supposed to be, either to pay debts or to distribute it to the other beneficiaries.
Okay. Let's touch on the power of attorney before we leave this subject, as well as Virginia Advanced Healthcare Directive.
Yes. Well, a power of attorney is a document that everyone should have, because you can look at the percentages that insurance companies that want to sell you a disability insurance policy can show you. Many people at some point in their lives will become disabled and won't be able to handle their affairs. And if you have a good, general, durable power of attorney, then you designate a person or persons. Typically, people will designate their spouse as the primary agent or attorney in fact under a power of attorney, and then if the spouse is not available or unwilling to act or can't act because they're incapacitated as well, then typically people will designate their children to act as their agents, and then those children or whoever the agent is can handle all of your financial affairs and can even get involved with estate planning to a certain extent, because you can give them control over assets in your revocable living trust if that's the document that you're using as a will substitute. The Advanced Medical Directive is a document that you would sign if it was your wish that if you are determined to be in a terminal condition and you can't communicate with the healthcare providers, and the doctor says, this person is going to die soon, and there's not a medically likelihood of their recovery, then you've indicated, don't connect me to life support, or if you have connected me, my wish is that you disconnect me. That's the first component of an advanced medical directive, and you don't have to put that in there. But and the second component is listing the authority that you want the agents that you designate to make healthcare decisions for you, and that can include authority over who visits you in the hospital. There's some people that you might not want to come visit you in the hospital or the assisted living facility, and you can give your agent the authority to control that. You can also give them the authority to determine what kind of medication you should have, what kind of treatment you should have if you have a certain medical condition. I had one client one time who did not want to have our Western kind of medicine. She only wanted Chinese medical techniques utilized for her, and so we wrote that into her advanced medical directive. I had another client who was a very devout Catholic, and the Catholic Center for Biomedical Ethics has provisions that you can insert into an advanced medical directive to ensure that that your wishes, your moral and religious and philosophical wishes with regard to your health care are carried out when you're not in, where you physically are incapable for medical reasons of communicating with the doctors yourself.
Okay, well, it looks like we're going to have a part 2 on this because there's a lot of material we did not cover.
Well, I'll be glad to come back.
Okay, so let's wrap it up now. It looks like we have about 2 minutes left. What would you like to leave with our clients about this subject matter?
Well, I would like for everyone to know that it's important to think about planning for your future, planning for your death, planning the way that your assets will pass at your death, and you don't want to wait until you're at death's door to do that.
Okay, that's great. All right, this is Melvin Burris. I'm your host for the Neighborhood Law Center. You can go to Neighborhood Law Center on neighborhoodlawcenter.com to see some other programs we have. And also just we'll be looking forward to seeing you next week. Peace and God bless.